judgment in appeals, Eclairs Group Limited and Glengary Overseas Limited and JKX Oil and Gas plc.
Lord Sumption will explain the judgment of the court.
This appeal arises out of a battle for control of JKX Oil and Gas, an English company listed on the London Stock Exchange, whose business consists in the development and exploitation of oil and gas reserves, mainly in Russia and the Ukraine. The company has not prospered of late, and as a result, its share price has fallen to historically low levels. In 2013, the directors of JKX perceived that the company had become the target of a corporate raid by two companies, Eclairs and Glengary, both incorporated in the British Virgin Islands. Eclairs is a company controlled by trusts associated with Mr. Igor Kolomoisky and Mr. Gennady Bogolyubov. Mr. Kolomoisky is a prominent Ukrainian businessman and politician, and Mr. Bogolyubov is his business associate. Glengary is a company controlled by Mr. Alexander Zhukov, in which his right-hand man, Mr. Raskevich, has a small holding. Between them, Eclairs and Glengary own about 38% of the shares of JKX. In March 2013, Eclairs wrote to JKX, calling upon it to requisition an extraordinary general meeting in order to remove the chief executive and the commercial director from the board and to appoint 3 new directors. Shortly afterwards, when the board convened an annual general meeting for the 5th of June, Eclairs made it clear that they intended to vote against the re-election of the chief executive to the board and also against a number of other resolutions to be put forward by the directors. Inquiries suggested that this move had been concerted between Mr. Kolomoisky and Mr. Zhukov and that the proposed new directors were associates of theirs. One of the tools available to a public company seeking to resist the covert acquisition of control by raiders is a statutory disclosure notice calling for information about the persons interested in its shares. The board of JKX responded to Eclairs' request for an extraordinary general meeting by serving disclosure notices on Eclairs and Glengary and their controllers, seeking information about the number of shares held, their beneficial ownership, and any agreements or arrangements between the various persons interested in them. The responses, which were received promptly, admitted the existence of interests in the shares, but denied that the addressees of the requests were party to any agreement or arrangement among themselves. The board of JKX regarded these responses as unsatisfactory, mainly because they failed to disclose any arrangement which the directors felt sure existed between the two companies for concerted action to influence or control JKX. Under the company's articles, if the board has reasonable cause to believe that the answers to its inquiries are unsatisfactory, they may issue a restriction notice suspending the shareholders' rights, including their rights to vote at a general meeting. The board of JKX decided to issue restriction notices to Eclairs and Glengary. This appeal is about the validity of those notices. In order for them to be valid, 2 conditions had to be satisfied. The first was imposed by the articles. The directors must have reasonable cause to believe that the answers are inaccurate or incomplete. The judge found that they did have reasonable cause, and there is no longer any dispute about that. The second condition, which is disputed, arises from a rule of company law known as the proper purpose rule. The rule is that directors may exercise their powers only for proper purposes of the company. The 2 BVI companies contended that the restriction notices had not been issued for proper purposes of the company, but in order to prevent them from being able to vote down the directors' resolutions at the forthcoming annual general meeting. The trial judge found that this allegation was proved. After hearing evidence from most of the directors, he concluded that that had indeed been their purpose. He held that this was not a proper purpose for which to issue restriction notices and set them aside. The Court of Appeal disagreed. They considered that the proper purpose rule had no application to decisions to issue restriction notices and reversed the judge. The Supreme Court unanimously allows the appeal and restores the order of the trial judge. The purpose of directors' powers to issue restriction notices is to induce those who are required to provide information to comply with the requirement, to impose sanctions on those who refuse to comply, and to protect the company and its shareholders against having to make decisions in ignorance of potentially relevant facts. It is no part of the purpose of directors' powers to enable them to manipulate the outcome of a general meeting of creditors. This is because directors owe a duty of undivided loyalty to the company, for whose observance they are answerable to the shareholders. Allowing them to use their powers to influence or control the collective decisions of the shareholders to whom they are answerable would be contrary to some basic features of the company's constitution. These principles apply just as much to the power to issue restriction notices as they do to the exercise of any other powers of directors. Indeed, it is particularly important in that context. Restriction notices are commonly used to enforce demands for information about shareholders in the course of a battle for control of the company. There is a well-known tendency of directors, which is illustrated in many of the decided cases, to use their powers not in the interests of the company, but in the interests of the existing management in the face of criticism from shareholders. The proper purpose rule is a valuable constraint on that tendency and should not be watered down.